OMR mismatch tainted.
I'll be joining.
Please, just
I'll be joining an
just
issue.
OMR mismatch tainted. Comma OMR has been
Blank.
fraudulently has been done. Just third OMR blank is also tainted. In addition to that, this is also there. I mean, tainted is a broad term.
Yes, because these are what court is saying that paragraph 363, or the main paragraph of judgment dated 22nd April 2024 of the division bench, where it is stated that there are three categories of tainted. That is the probable categories, not all categories. Not all categories. It is not possible to pinpoint all the categories of
division bench has pinpointed that from the division bench, when the bench presided over by Justice Basa, and also the Supreme Court, the tainted candidate in one case, it has been given the chart has been given OMR. These are on the basis of the CBI, right?
Yes.
These are all tainted. Second is beyond the panel which have been taken. Rank jumping. I was forgotten one. Rank jumping was also.
I am not rank jumping. I have shown the list of rank jumping.
Rank jumping was also tainted. Rank jumping was also tainted.
Persons who have been appointed outside the panel.
What I am saying, in addition, these are the
outside the panel includes rank jumping.
It cannot be. It cannot be said OMR mismatch is not tainted. Blank OMR is not tainted. OMR mismatch is
blank OMR is tainted.
And also submitted blank OMR.
Yes,
blank OMR is classified as tainted under paragraph 363(4).
Yes, not that is. But here, what you want to say that we are not.
Mr. Lahiri wants to say that there are only three categories of tainted candidates.
No,
under paragraph 363(4). What are those categories? Candidates appointed beyond the panel. Candidates appointed outside the panel, and candidates who submitted blank OMR.
But then in that case, OMR mismatch is not.
Blank OMR and OMR mismatch
OMR
mismatch is a 1 marks also.
OMR mismatch is the greatest tainted candidates. Everything has been fallen because of the OMR mismatch.
Now, my lord, I'll show
OMR
your lordship.
And
may I complete, my lord? Senior friend will get.
This is not nothing to be talked much. We are also facing the courts also. Let me be very clear. We are treating them as a tainted. We are treating them as a tainted.
But persons who are supposed to be treated as tainted is not being treated as tainted.
You challenge that.
I have challenged here and now.
Take them party and come back. Then we will see that.
In either of the litigations.
Now, yesterday, although I was not there, I have received the instructions from my advocate on record. Yesterday also, one of the matter was taken up, and other petitions have been dismissed. One there we have said, they have shown. It will be very clear to your lordship if I say that there are mismatching of the list of the tainted and the CBI list, which we have said the list which has been published by the SSC, that they were all appointed, right? And the difference between that, they are also tainted. We are also considering their admit cards also. And we have said also there may be some, everything is not filtered at 5 lakhs. Applications are there, it may not, but ultimately, if anyone is there, we'll cancel. And because this is the order of your lordship's order, which has been upheld,
that is what I'm saying.
They cannot be accepted at all.
That is what I'm.
Even if I miss anywhere, let's assume, if I miss anywhere, that's where I'm missing. He has got it.
At the time of verification.
At the time of verification, I will do it.
But that is what I'm saying. If I appear in the examination,
if you appear in the examination, Supreme Court
can cancel me. I will get an opportunity. I want to go to Jamuna. I want to go to, but after appearing in the examinations, not like this. No, if I miss examination, man, I'll not be able to appear. 156 has not been accepted. 156 has not been accepted. 156 has not been accepted. Let us yes see.
156 of the writ petition.
Supreme Court order. Lordship is taking the Supreme Court order. Paragraph.
3rd April 2025 order.
Yes. 156 and second volume order.
Paragraph
25. Page 1.
Just.
Okay. First, similar in the written submission filed on behalf of WPSSC in this court, 2 tables have been furnished. Table 1 pertains to candidates who are.
Just a minute.
Lordship, kindly see, these are the submissions which have been recorded.
In the written submission filed on behalf of the WPSSC in this court, 2 tables have been furnished. Table 1 pertains to candidates who earlier jumped rank were appointed despite not being in panel. It is the assistant is 74 rank jump out of panel but still appointed at 111. Assistant teacher for class 11, 12, 20 out of panel but still appointed 80. Well, this is the 9 and 10. That's the reason I'm saying. Then table 2 find the WSC for candidates who are appointed by manipulating the OMR state. Table 2 is as under.
Table 2 assistant teachers plus
OMR score mismatch for CBI image.
where you are getting the manipulating this. Yes.
Yes. Who are appointed by manipulating the OMR states.
These are the submissions.
No.
I'll show. These have not been accepted.
Tainted. What is tainted?
So kindly see paragraph 28.
Therefore, kindly see and answer 952. Then assistant teacher, a candidate who appointed, I will not show. Assistant teacher for class 9 and 7. Then in another it is a file on camera in this court. It is claimed that on further verification, the following details of the candidates who either jumped rank or were appointed despite not being in the panel came to light. Rank jump 74. That's a particular.
Table 2.
Next.
Paragraph 26.
Paragraph 26. 26. Table A, table B.
Yes. Yes.
Therefore, these are tainted. But why the Supreme Court has said all tainted?
Kindly reads.
Remove.
Kindly reads on.
Just 1 minute.
Yes. No, accent. I understand. I know.
3 minutes. Therefore, these all were terminated. Number 1. Then the Supreme Court will file the applications for all. I mean, both file the applications for group 9, 10. 9, 10, SC. Supreme Court has said, we are allowing you to keep this for the timing. Number 1, up to 31st December, you have to complete the examination. Number 2, no tainted candidates should be allowed. First, he has not challenged the termination. Second, he has not.
There is no termination as such, as of today.
Cancellation of appointment.
There is nothing.
By Supreme Court.
Nothing. That is by Supreme Court. Thereafter, it has not been indicated to us. Where is the cause of action? How will I come and say?
Don't come. Don't be excited.
In this matter, don't raise your voice.
Second, my lord. Second is.
He was my leader. He knows everything.
Lordship has pointed out. Already pointed out. You have not been allowed to join. After 31st December, why did you not?
Where is that order? That candidate 17th. This is 17th April.
17th April is page 175.
175.
Now, my lord, kindly, before going there, kindly come to
Just a minute.
page paragraph. No, একটা কিছু না আমি শেষ করব বলেই দিয়েছে শুনুন
May I read? We are inclined to accept 175.
17th April order.
175.
Yes. The examination and the entire recruitment process shall be completed by 31st December.
31st December 20.
Then paragraph 3, the state government and the applicant
shall file the respective evidence by 31st May 2001. It shows there is copy of the advertisement for the place recruitment as well as the civil therefore so as to ensure completion of the recruitment process by 31st December 2000. In case the advertisement is not processed by transport are not filed by the court, they have to put it order to the pass. Clarified this order cannot be read as a conferring in its we are not inclined to accept the prayer in present
CD.
No.
Oh, but where is the
Yes, sir. We are inclined to accept at the top line of the order or of the order first beginning. We are not inclined to accept the prayer made in the present application so far as not found to be tainted subject to the following. And last.
So this is the prayer made by the West Bengal Board of Secondary Education.
Board.
Yes. Permitting them to permitting the untainted to work.
No.
That was accepted.
They filed an application to allow everyone. Board Supreme Court has said no. Kindly come to the last lines.
That is CD.
This order in respect of action not found to be tainted in that student undergoing study.
Which paragraph?
Last part 1. Page 176.
That is in connection with Group C, Group D.
No. After that. What has prompted us to pass this order? In respect of the assistant teachers.
Just it. Place it, which paragraph?
Just come to 176. Darsha, come to 170.
This, you are on the order date 17th April 2025. Passed on miscellaneous application 709 of 2025.
Yes.
Which paragraph you are relying upon?
Let this page kindly come to next page.
Yes.
170.
There are 1, 2, 3, 4 paragraphs.
After that, we clarify that this order shall not be read as a confirming any special right or advantage on the advocate teacher in so far as the press recruitment process is concerned. That is untainted. Then we are not inclined to accept the prayer in the present application so far as non-teaching posts in Group C and D are concerned, as the number of appointees specifically found to be tainted in the said group is substantively high. And secondly, what has prompted to us to pass this order in respect of assistant teachers not found to be tainted is that students undergoing study presently should not suffer on account of the lack of teacher and a lackness and failure, which have resulted in the order passed by the court.
So that after this this observation, we were not permitted. After this observation, you were not permitted. After this observation, you are not permitted to
No, my lord,
to work.
I am not, my lord.
Which goes to show that you are considered as tainted.
That is, my lord, that is the interpretation. We have not been informed of anything.
Yes.
We have not been informed. This is for the first time it appears that our list, our names have been my lord, taken into account. Now, and Mr. Bandyopadhyay has shown, my lord, paragraph 2025 kindly comes to paragraph 28 of that Supreme Court. That your lordship is seeing the Supreme Court from your lordship's brief, my lord. Your lordship's brief, my lord. Your lordship is having Supreme Court alada kore. Yes, that one.
Yes, there are only 363 paragraph.
Now, my lord, no, not 360. The Honorable Supreme Court judgment, main judgment.
Yes,
paragraph 28. Kindly see paragraph 28. Because Mr. Bandyopadhyay has shown, my lord, these submissions, which starts from paragraph 25. Submissions, the charts. Now, in view of the fact that, my lord, the charts were contradicting and the charts have been subsequently improved and all these things, that is the my lord, finding of the Supreme Court. Kindly sees what the Supreme Court holds. Paragraph 27. From that, at this stage, we would like to kindly skips paragraph 28 at internal page 31 of the judgment. I'm sorry, my lord, I'm traveling with lordship, my lord.
Yes, paragraph 28.
We may have accepted this argument.
Yes.
If WBSSC had the original physical OMR sheets or the mirror copies of the OMR sheets. So the previous arguments are not being accepted. Chart also. However, WBSSC accepts that they do not have the physical OMR sheets as they were destroyed in terms of Rule 21 of the classes such and such, which required retention of OMR sheets for only 1 year. Rule 21 of the such and such, well, it is quoted. Thereafter, admittedly, the OMR sheets were applied for non-teachings. Well, I'm keeping that relates to non-teaching. Thereafter, paragraph 30. Moreover, given that the recruitment process was ongoing even after 1 year validity period of the panel, there is no justification for destruction of OMR sheets. It is apparent that the time period specified in Rule 21 was coincide with the time period specified for validity of the panel. Further, WBSSC did not maintain the mirror copies of the OMR sheets in their computer records. Thus, the destruction of the physical OMR sheets and the failure to maintain scanned images of the OMR sheets are significant factors which were rightly taken into consideration by the High Court. We concur. Thereafter, paragraph 31 that I have already placed, WBSSC has also tried to justify the extension of the term of the panel as noted above. The term period of 1 year specified in such and such for destruction of OMR sheets coincides. There is no doubt that the counseling process and the appointments made to the post of assistant teachers were made after the expiry of panel. That matter I have indicated to your lordship what is the list that they have given before the division bench. They have not been put in the tainted list. It is illegal. This is illegal and contrary to the rules. Reliance on the orders stroke judgments of the High Court in stray cases of rank jumping, where the High Court directed to appoint candidates after the expiry of validity panel, would not have any significance. So therefore, Supreme Court deprecates the persons who have been appointed after expiry of the panel. And the list is there before a lordship. And I can substantiate at least one candidate. And I can substantiate the entire list. None of the names of this list who have been appointed in the 8th round of counseling, which was held on 3rd August 2020, have been included in the tainted list. And we are outside. We have been included.
Yes, yes, that's all.
Now, my lord, kindly, this list I have shown to
Yes,
your
yes,
lordship.
Mr. Sen.
And my lord, another point,
Yes, yes, yes.
1%, my lord, another, my lord, item number 4 is different. Kindly, my lord, takes up item number 4. Item number 4. 7 and 4 is on the same. Kindly, it gives me 1 minute time. I'll place item number 4 because they are the affidavit of the SSC says in the first round of litigation that these persons are not tainted. It says I'll rely upon that one. 19. That is also 4 is also 19. And the only distinction feature between 910 and 1112 is in 910 the OMRs were published. But in 1112, the OMRs were directed to be published by the Honorable Justice Abhijit Gangobadhyay. We moved, my lord, an intra-court appeal that was stayed, and the Honorable Supreme Court directed that only the names will be published, the OMRs. So that 1112 candidate, as of today, do not know what is their OMRs. There is a direction in the Honorable Division Bench presided over Justice Devanshu Basa's judgment to publish the OMRs.
Item number 7 is relating to 910. Basically, points are saying what your lordship is interpreting paragraph 363 of the division bench order. Your lordship's view is that is only illustrative. That is not exhaustive. But I would like to just read paragraph 363 with the Supreme Court judgment to show that that 3 becomes exhaustive because of only the fact that the Supreme Court was of the view that there was no original MR sheet. Also, OMR sheet, there was no original which was, and the originals were destroyed. So therefore, it was not, and there were several disputes raised with regard to the scan and the mirror copies.
Yes.
So therefore, it cannot be said with certainty that other irregularities concerning the OMR sheet. So therefore, what could be said is that blank OMR sheet. That is something which is conclusive to make it within the category of tainted. But whether the other irregularities relating to the OMR sheet will also fall within the tainted category, for that one has to come to a conclusive conclusion. Yes, this is the copy which is produced in the original, or it is exact copy of the original.
Your whether the petitioner is working?
No. December 31. That is
not working.
Not working.
So what steps you did?
But that I understand. But here, my lord.
No. What you understand? Why steps were not taken?
Yes, well, that is what I wanted to answer, your lordship.
That others are permitted. Why you are not permitted?
But that I was not part of the Supreme Court.
No, that is not required. You are not part of. When you are not permitted to work till 31st of December, you should have approached the authority for taking steps. That why I am being I am not being permitted to work till 31st.
Because then they will show that this
31st of December 2025.
That the Supreme Court ordered that is going to be cited.
Yes. So therefore, you are being treated as untainted from the after the list was prepared containing names who are permitted to work till 31st December.
Well, this does not categorize or segregate the tainted
goes to
or
show
untainted.
that you are being treated as tainted candidate.
Well, your lordship will kindly
only those candidates who are treated as only those candidates who are treated as untainted were permitted till 31st of December in terms of the order dated 17th of April.
Well, with the greatest of respect, well, that division, if it was already possible, then the Supreme Court would not cancel.
For that, Mr.
Would not have cancelled the entire process.
There was no requirement to wait till publication of this list.
No, because I have already got the admit card. Before publication of the list, they treated me as untainted, and they gave me the admit card. So then, my lord, where is my cause of action? Very well, I was not working, but provision was made for appearance in the next exam, next recruitment process. I was allowed to participate in the next recruitment. Admit card is already given. Well, how will I know that a different list of untainted and tainted will now be segregation?
Approach the Supreme Court in an IA in a pending matter.
Well, kindly.
The Supreme Court is insisting on the matter. Why court will consider?
Therefore, now comes the balance of convenience. Your lordship will see if the exam is on Sunday. So, my lord, if even after the exam, my fate can be decided. Even after the exam, my fate can be decided. My answer may not be considered or whatever. But today, if a firm decision is taken without there being active segregation of this distinction of tainted and untainted, then, my lord, my right will be lost forever. Yes. There is a question of balance of convenience. But here, my lord, that is why I just want to refer to 363. Why that is exhaustive? That is exhaustive because of the Supreme Court judgment. Malad, just the paragraphs which Mr. Lahiri has placed, Malad, that is extremely relevant. Malad, kindly just see once, Malad. Your Lordship kindly sees the paragraph.
Yes, that has been placed. I have
No,
seen.
I am not on that. I am
That has
saying,
been placed.
I'm therefore saying that Supreme Court definitely came to the conclusion that first of all, there is destruction of original. Second, whatever copy is being produced, there is substantial cloud. If there was no substantial cloud, then
So in your case, admit cards were issued, then thereafter you were enlisted as tainted.
My case also.
thereafter I have been enlisted as and as a yes, admit card has been cancelled. Cancelled. Has been cancelled. That is what I have challenged here, Malad.
I have not shown the cancellation of the admit cards. I can show it in the cancellation screenshot.
Is any addition by anybody?
Item number
I rest my submission.
this candidate. This particular my lord teacher was my lord working, and her services were not terminated entire, but has been terminated pursuant to order of the Honorable Supreme Court. In that matter, my lord, an affidavit was filed by the SSC.
3rd of April.
Yes, yes. Not working after 3rd of April. Now, page 62 is the affidavit which has been filed by the SSC before the single bench, which ultimately went to the Supreme Court. There, the SSC had said, but what the mismatch of marks, my lord, were there in respect of this particular candidate was to the tune of only 1 mark. The OMR sheet, if evaluated, would come to say 20. I have been given, would come to 19. I have been given 20. That is the only 1 mark. The SSC said in respect of this particular candidate, kindly comes to, may I just place paragraph 63, page 63, first paragraph. Second paragraph. Secondly, in respect of
Your that writ petition.
of yes, item number 4, madam. But this was never placed nowhere in the previous rounds of litigations. Those are matter on the points of principle.
Hey, Daughter. Page.
Only this. Now, my lord, page 63. This is the affidavit in respect of 910 candidates. Subhamoy Bhuiya was the 910 candidate, one of the 910 my lord, writ petitions where it was been heard before the Honorable Justice, my lord, Vishwajit Basu. This affidavit was placed.
This is item number 4.
4, yes.
Page 63.
Page 62 is the affidavit. I will be placing from page 63 and 64. The order, by an order dated 6th February, the court was, the commission was directed, page 63, it is recorded, on 6/2/2000.
Affidavit by whom?
By the SSC.
Yes.
On 6/2/2023, in course of the hearing, the instant petition, the court was pleased to direct learned advocate appearing on behalf of the commission to file a report in the form of affidavit to the modality to be adapted by the commission to exercise its powers under Rule 17 of the such and such.
There no admit card was issued.
Yes.
Yeah, no admit card was issued.
Yes, admit card issued, cancel. All matters. Admit card issued, cancel.
All matters.
All matters. Admit card, I can show one of the screenshots. I have not shown before, Lordship. I will show one of the screenshots. My lord, here, that is February 2023. Why it was directed? Why you have not?
Which paragraph you are reading?
Paragraph 3. To give the background. Why this affidavit has been given. I'm sorry, ma'am. I'll just skip over the. I'll come to the relevant part. This is only to give the background, since your Lordship is reading each and every paragraph. Rule 17 was the rule which empowers the SSC to withdraw the recommendation even after the appointment. That was issues with regard to Rule 17, and subsequently now the issue has been settled. It has not been settled, though it has not been taken up. The Supreme Court had directed this Honorable Court to settle. This Honorable Court didn't settle it. We have gone to the Supreme Court and lost, so therefore no point. Now, kindly comes to paragraph 4. In reply to the above, I submit as follows regarding the steps contemplated to deal with the candidate under such and such. Firstly, it is respectfully submitted that the marks of 15 candidates were increased by 1 mark in compliance with order of the Honorable Court, which I am not. Next is the category where I will fall. Secondly, in respect of 937 candidates, it is found that the marks difference vary from 1 to 53. considering the large number of cases to be handled, it is respectfully submitted that SSC proposes to move from the most palpable severe irregularities to the least severities. That is, from the case where the marks difference is 53 to the case where the marks difference is 1. 1 is the petitioner before lordship. In the latter case, it is respectfully submitted that the further due diligence is called for and SSC will deal with such cases at the end. So therefore,
the marks difference ranging from 53 to 1.
Now kindly comes to page 76. Yes. Affidavit of the SSC before the division bench. This is the affidavit that I have shown your lordship. This is also annexed here.
But somehow the issue has to be put to an end.
Yes, it has to be
So
put to an end.
therefore today,
Allows me to participate and says that
therefore
even if you are
today, when
appointed,
the Supreme Court has said and the Commission has issued a list, and the issue is in session of the Supreme Court, at this stage, court is not inclined to interpret this.
I understand your lordship's binding, but balance of confidence.
Now the court, in that event, if I accept your contention, these 2018 candidates who are enlisted as tainted, one after another, all their credibility has to be considered.
But
it's not
this
possible.
exercise has to be considered at one stage or not. This exercise has not been done. And 1 point ballot, I have missed ballot. Ballot 116 ballot.
Just 1 point.
Yes. But only, sir, এক সেকেন্ড এমনিতে হারিয়ে দিচ্ছে দাও।
Just আমার রেকর্ডটা দরকার আলটিমেটলি সুপ্রিম কোর্টে যাবে তখন আমাকে
না না
you were there, you didn't argue Mr. Bandyopadhyay. No, well, one question is this, Miller.
Yes.
According to CBI report, it is a case of mismatch. Right? Since it is a case of mismatch, we have
OMR mismatch.
That OMR mismatch, that is the reason we have treated it as a tainted. Number 1. Number 2, if his submission is accepted, and see, according to OMR marks, according to image received from CBI, then it's 34, right? And server
In whose case? 34?
In this case. Server marks was
not in this case 70
I am according to your case.
মানে প্রথমটা আমি
I mean, before I am talking about
4-1 এক মাস সম্পাদক হ্যাঁ সম্পাদক বলুন হ্যাঁ সম্পাদক
if his contention is accepted, then cutoff mark will be 68, so that he can call in the interview. And if CBI is accepted, then his cutoff, his mark is 67. He is not at all will not be called. First thing, later, am I clear to Lord, says that I am treating everyone, if the mismatch 1, 2, 3, it doesn't matter to me. CBI has said it's a mismatch, I am treating him tainted. I am treating him tainted. That on the basis of the CBI. Number 2, even if his argument is accepted, then even then he cannot be allowed to by the court because CBI marks has to be taken into account. Then he is not coming to the cutoff. Less one cutoff.
Charge sheet ballot CBI says
Yes, CBI is saying that it's mismatch. You are
I
treating
am
it
accepting it's a mismatch.
that OMR mismatch.
OMR mismatch.
Then what on cutoff marks? What is your submission?
Cutoff marks. First of all, if it is a mismatch, let's assume that he is more than the cutoff marks. Even in that case, I will treat him as a tainted. His case is 1 number difference, right? He is saying whatever the number 1, if his 1 number is taken, then he is coming to the cutoff mark. If the CBI number is taken, then he is less than cutoff mark, 1 number.
No, well,
because I have kindly record this. When it will go to Supreme Court, then I have Supreme Court will
In case of suppose there are 50 candidates. In case of all candidates, these separate facts are to be narrated.
No, I don't think so. Malad, kindly see. No,
at 1 point,
my submission is this. What is his submission? My submission is very clear. My submission is
justice will be done.
If is a mismatch is there, whether you have got 100 or you have got 50, it is immaterial to me. You may be brilliant, but mismatch is there. CBI is giving you the report is a mismatch. Finished. I am treating him as mismatch. Tainted.
Now regarding cutoff marks, please repeat your submission.
Not what is saying
That if suppose a cutoff marks is 50,
if his contention is taken, is
এই যে এখানে দেখো না এই তো লাগিয়ে রেখেছি আমি রাহুল এটা দেখিয়ে বল এখানে লেখা আছে এই যে আমার নাম্বার শম্পা ঘোষ এইখানে 88
because I have to in that I have to file an affidavit.
That's what I'm saying.
Leave aside. Kindly record my submission that his case I have since it is mismatch. Whatever the number he has got, it doesn't matter to me. It's a mismatch. CBI has given the report. I am treating him as a tainted.
1 marks mismatch is
Well, anyway, that is I
allege, and that is also a question was erroneous estimate. They have said in the RTI application that there may be two provable
first
answers.
let us be very clear. Let me very clear to your lordship. Let me very clear to you.
এটা চার
Let me very clear to you.
এখানে
We
রাখো
are-
ওটা
সোমনাথ,
সরিয়ে নিও না,
সোমনাথ।
ওখানে রাখো
সোমনাথ,
We are proceeding on the
ফার্স্ট প্লেস করলো ওইটা দাও
সোমনাথ,
we are proceeding on the basis of the CBI
861,
report.
20861.
We don't have much discretion to do. We don't have much discretion to do. We are proceeding on the basis of the CBI report. Whatever the CBI has given the report, and on that basis, the entire proceeding has been done. This court, Supreme
Now,
Court,
today, if you enter into the, if you make submission inviting the court to enter into the issue of cut-off marks, then I need to give direction for filing.
but
Then I need to give direction for filing affidavit.
my lord, what I am submitting,
It is there in the Supreme Court
Well,
order,
if I-
Sonali Das order. Supreme Court has said that everyone has to be, it has to be heard.
no, Supreme Court order kindly see.
Sonali Das.
Yes, I know that.
I am in Sonali Das category, 33.
No. What has happened in that matter? In that matter, the Sonali Das filed the petition prior to the delivery of the judgment and other things.
My case is also that. I have also
You are
filed.
coming with a new petition.
No,
Why?
this is the new petition. The previous petition has not been dismissed and it is.
You have not made an application in that petition.
Yes, I have made.
Now, my lord, kindly come to page 120.
I know my case, Malad. I know my facts, Malad.
You know, I know. You know. Only I do not.
You know that I know. You know that I know.
You know that I do.
You know that I know. Malad, we have
This is
approached
my
earlier.
submission, kindly record that.
Item number 4, I can show, Malad, we have appeared and my writ petition number will be reflected from the order passed by the Honorable Justice Devanshu Basak
Read
division.
petition উপর একসঙ্গে করে দেবে।
And Malad, one page, Malad,
In this writ petition,
page 123, FCBI affidavit, only 20 are blank OMRs.
writ petitions are filed
Big matter. যাচ্ছি আমি
Questioning.
আপনার report দিচ্ছি।
publication of list containing names of tainted candidates in the memo dated 30th August 2025 issued by the Secretary West Bengal Central School Service Commission. The list dated 30th August 2025 features names of 104 names of 1804 candidates who have been declared as tainted candidates in connection with their participation in first state level selection test 2016 for classes 9, 10, 11, for classes 9 and 10 and 11 and 12. 2016 for classes 9 and 10 and 11 and 12.
কালকে সার্থকে দিতে গিয়েছিল সার্থক আজকে সকালবেলায় চলে গেছে হয়তো আপলোড হলো
Next one. At the outset, it needs to be recorded that in terms of order dated 28 August 2025 passed on special leave to appeal within bracket C number 23784/2024 within bracket Bijoy Bishwas and others versus State of West Bengal and others. List was said list dated 30 August 2025 was published by the West Bengal Central School Service Commission within bracket hereinafter referred to as commission, quote unquote. Next slide. As per cases, as per case presented on behalf of the petitioners. they either participated in first SLST 2016 for classes 9, 10 or first SLST 2016 for classes 11 and 12. But they lost job in terms of the judgment of the Honorable Supreme Court dated 3rd April 2025, passed on civil appeal arising out of special leave petition within bracket civil close bracket 9586 of 2024, State of West Bengal versus Boishaki Bhattacharyya Chatterjee and others. Since inter-selection process was declared null and void on finding egregious
May I assist, Your Lordship?
illegalities. Stop. According to the petitioners, after recruitment notification was published,
May 2025. Now she wants the date of the recruitment, second recruitment notification.
30th May, where is the notification?
Yes, that is at page 179 of the second volume. That order is 17th April.
On 30th May 2025, on promulgation of the West Bengal School Service Commission within bracket selection for appointment to the posts of assistant teachers for upper primary level of classes within bracket except work education and physical education close bracket
Upper primary.
classes 9, 10 and classes 11 and 12 close bracket rules 2025. Herein are referred to as said rules of 2025. They were issued admit card, but based on admit cards, but based on list dated 30th August 2025, issued by the commission containing names of tainted candidates, their admit cards were cancelled.
That cancellation is 257, 258.
Prompting the triggering present petitions. Stop. Next paragraph. Mr. Anindo Lahiri, learned senior advocate, and Mr. Shakko Sen, learned senior advocate, representing some of the petitioners, have placed reliance on the judgment dated 22nd April 2024 passed by the Honorable Division Bench on batch of matters, first one being WPA 30649 of 2016, Boishaki Bhattacharyya Chatterjee, within bracket Chatterjee and others versus State of West Bengal and others. In order to contain that petitioners are not coming under the category of tainted candidates as defined in paragraph 363 within bracket small Roman 4 of the said judgment dated 22nd April 2024. So it is further contended that as per observations made by the Honorable Division Bench in the judgment dated 22nd April 2024, persons who had been appointed outside the panel or persons who were appointed after expiry of the panel or who submitted blank OMR sheets ought to be treated as tainted candidates, but petitioners are not coming under those categories. Therefore, cancellation of their admit cards by publication of list on 30th August 2025 was not warranted, was not warranted. Stop.
Thereafter আমার division bench, sir.
In addition thereto, reliance is placed on observations made by the Honorable Supreme Court in the judgment dated 3rd April 2025, passed in Boishaki Bhattacharya Chatterjee, is relied upon, wherein it was discussed It was not significant. So far, stray cases of rank jumping and direction given by the High Court to appoint candidates after expiry of the validity of the panel. Stop. Based on which, based on several considerations, including rank jumping and appointment of candidates after expiry of validity of panel, ultimately conclusion was derived in paragraph 45 of the judgment dated 3rd April 2025 by the Honorable Supreme Court. Wherein it was held that there was no valid ground or reason to interfere with the direction of the High Court, that the services of tainted candidates, where appointed, must be terminated, and they should be required to refund any salaries and payments received. In other way, it is submitted that observation made by the Honorable Division Bench in the judgment dated 22nd April 2024 especially in paragraph 363 within bracket 4, Roman 4 was not interfered with. Therefore, identification of tainted candidates needs to be based on 3 categories as delineated in paragraph 363 within bracket 4 and not beyond this.
Division bench is at
Stop.
page 238. Division bench that I have relied upon, Justice Somen Sen, is at page 230.
Next paragraph. On the contrary, Mr. Bandyopadhyay, Mr. Kullan Bandyopadhyay, learned senior advocate representing Commission, submits that apart from aforesaid 3 categories of tainted candidates, as described in paragraph 363(4) of the judgment of the Honorable Division Bench dated 22nd April 2024. Other categories of tainted candidates involving rank jumping, candidates identified by CBI were taken into consideration by the Honorable Supreme Court in the judgment dated 3rd April 2025 passed in Bhattacharyya Chatterjee Supla, as it emanates, as it appears from paragraph 25 and 26 of the said judgment. Stop. It is specifically submitted list of tainted candidates dated 30th August 2025 is prepared based on CBI based on report of CBI which says there are cases of OMR mismatch, and commission found them as tainted, and found them as tainted, and those candidates were included in the list dated 30th August 2025. According to the commission, categories of tainted candidates ought not to be confined to the categories as contained in paragraph 363 within bracket 4 of the judgment of the Honorable Division Bench dated 22nd April 2025. Stop. Next paragraph, it is also submitted on behalf of commission that an order was passed by the Honorable Supreme Court on miscellaneous application number 709 of 2025 in civil appeal number 4805 of 2025 within bracket West Bengal Board of Secondary Education versus Bhattacharyya within bracket Chatterjee and others, whereby the Honorable Supreme Court permitted only those assistant teachers who were not found to be tainted to continue to function as assistant teachers till 31st December 2025. Stop. Authorities, in terms of the order of the Honorable Supreme Court dated 17th April 2025, finding only identifying only untainted teachers, permitted them to permitted them to work till 31st December 2025, not others. None of the petitioners before this court today are permitted to are presently working as assistant teachers in their respective schools based on their selection in connection with first SLST 2016 for classes 9, 10, and 11 and 12. Therefore, petitioners may not be regarded as may not be regarded as untainted teachers. Next paragraph. Reliance is also placed on two orders of the Honorable Supreme Court, one dated 28 August 2025, passed in special leave to appeal within bracket C, number 23784 of /2025, within bracket Bijoy, Bishwas and others versus State of West Bengal and others, and order dated 29th August 2025, passed in special leave petition within bracket civil close bracket diary number 46049/2025, within bracket Vivek Padia and others versus the State of West Bengal and others. So, it is contended that in terms of these two orders dated 28 August 2025 and 29th August 2025, list dated 30th August 2025 was published by the Commission containing names of tainted candidates, and both the matters are pending consideration before the Honorable Supreme Court. Next paragraph.
Lordship.
Having considered the next paragraph. Reliance is placed on paragraph 363 of the judgment of the Honorable Division. Reliance is placed on paragraph 363 within bracket 4 of the judgment dated 22nd April 2024, passed by the Honorable Division Bench in Boishakhi Bhattacharyya Chatterjee Supra. On behalf of the petitioners, in order to lay stress that only candidates who were appointed outside the panel comma, candidates who were appointed after expiry of panel, and the candidates who were appointed after submitting blank OMR sheets, only need to be regarded as tainted candidates, and petitioners are not coming within those three categories. But on perusal of extent of egregious fraud and illegalities, but on consideration of egregious illegalities and fraud, as found by the Honorable Supreme Court in the judgment dated 3rd April 2025, passed in Boishaki Bhattacharyya Chatterjee Shukla. Categorization of tainted candidates as made by the Honorable Division Bench in paragraph 363 is probable categorization comma there can be other good reasons for finding candidates to be treated as tainted. Stop. In consideration of gamut of illegalities and irregularities found by the Honorable Supreme Court and Honorable Division Bench as it transpires from the judgment dated 3rd April 2025 and 22nd April 2024, it is permissible to infer that there are different categories of tainted candidates beyond the stipulations contained in paragraph 363 of the judgment of the Honorable Division Bench dated 22nd April 2024. Stop. Today it is submitted on behalf of the Commission that based on that as per CBI, there are cases of OMR mismatch and and the candidates involved therein are identified as tainted candidates, and this court does not find fault with such offense. Next paragraph. Moreover, not a single petitioner before this court were permitted to function as assistant teacher in terms of the order of the Honorable Supreme Court dated 17th April 2025, passed on miscellaneous application number 709 of 2025, within bracket West Bengal Board of Secondary Education versus Boishaki Bhattacharyya Chatterjee and others. Stop. It is said order dated 17th April 2025. Assistant teachers for classes 9, 10 and classes 11 and 12 not found to be tainted were permitted to function as teachers in their respective schools for the academic interest of the students taking note of that lack of teachers and taking note of lapse of teachers in the school. Stop. But at the same time, Honorable Supreme Court framed time schedule for bringing the fresh selection process to its logical conclusion. That was by 31st December 2025. As per said order dated 17th April 2025, since only untainted teachers were permitted to work as assistant teacher till 31st December 2025, excluding petitioners here, excluding the present petitioners. This court has no hesitation in refusing their contentions, claiming to be untainted teachers. Stop. It needs to be recorded herein that when in terms of the when untainted teachers were permitted to continue their service till 31st December 2025, just after the order was passed on 17th April 2025. Present petitioners did not raise any demand, at least that is not demonstrated before this court. Semicolon. Stop. Next paragraph. Moreover, it is important to note here that the Honorable Supreme Court in order dated 28 August 2025 passed in Bijoy Vishwas Supra recorded the submission of the Learned Senior Counsel appearing for the commission that the list of tainted candidates who were selected and whose selection was set aside by the High Court and confirmed by the Honorable Supreme Court would be placed in the public domain in the website or on the website of the Commission within 7 days. Stop. That order was further considered by the Honorable Supreme Court in the order dated 29th August 2025, passed in Vivek Padia Supra. And following observation was made, which runs infra. এটা out করো। Next paragraph. Both the orders dated 28 August 2025 and 29th August 2025 now orders dated both the special leave petitions being special leave to appeal within bracket C number 23784 of 2025 and special leave petition within bracket civil diary number 46049/2025 are pending consideration before the Honorable Supreme Court. And in connection therewith, list dated 30th August 2025 was published, containing names of tainted candidates. Stop. Therefore, this court finds these are not fit cases where court should interfere with the lists dated 30th August 2025 containing names of tainted candidates. When the Honorable Supreme Court is insisting of the matters as aforesaid. Next paragraph. Hence, writ petitions stand dismissed. However, there shall be no orders to cause urgent exercise.
Well, 2 points, my lord, that the expiry panels are being continued and not included in the tainted list. In view of paragraph 31 of the Supreme Court order, my lord, kindly, well, I have made submissions that these persons who are expiry panel candidates have not been included in the tainted list. And my lord, in respect of which
Expiry panel candidates.
paragraph 31 of the Supreme Court order, where the Supreme Court has severely deprecated these persons are continuing. I am given the list also.
Paragraph 31.
31.
Yes, I have considered paragraph 31 that
Yes.
is rank jumping.
Rank jumping, but these candidates are continuing.
Where the High Court directed to appoint candidates after expiry of the validity of the panel, but
These are the
the Supreme Court found this is not a significant issue.
This is a significant. This is a significant issue. These illegalities and contrary to rules.
Jumping where the High Court directed to appoint candidates after expiry of the validity of the panel would not have any significant impact.
Yes, significant impact. Some of these persons had secured
It would not
impact.
would not have any significant impact.
Impact. That is, some of these candidates had shown orders by which they were directed to be appointed. That didn't have any significant impact because these candidates, one or two candidates, they had orders passed by the honorable.
I have recorded your submission based on observation made in paragraph 31 in my own way.
31. Lashe also record that persons who are expired because this will be
not that I have ignored your submission in connection with paragraph 31 of the judgment dated 23rd of April 2020.
Only one submission was that these are expiry candidates. They are also being continued. Kindly record one line. This is my contention, and this will be appearing from the
expiry panel.
Expiry after expiry of the panel, because we were appointed in 2018. Panel was valid till end of 2019. These candidates counseling was done in August 2020. So after expiry of panel, and
So
these,
they were allowed to continue.
they are allowed to continue. They are not even in the tainted list. Yes, they are in the CBI list. Everyone is there.
আচ্ছা ওখানে ওর যে সাবমিশন
Page 170.
রেকর্ড করেছে সেখানে একটা লাইন অ্যাড করো those candidates
Yes.
please allow me to record it. Yes, some of the candidates some of the candidates were allowed to continue, but they were appointed after expiry of the
Panel.
relevant panel.
Yes. List page 170.
After expiry of the panel.
Panel.
After expiry of the panel.
List is 117.
And their names do not feature
In the
in
tainted.
the list dated 30th August 2024.
We have excluded anybody whose name appeared in the CBI system.
And item number 4, Lordship is giving another judgment, or would be item number 4, 1 marks difference that your Lordship can, because there is a Sonali Das judgment of the Honorable Supreme Court which
No, I have
says
considered it as a whole. Separate consideration is not required.